All right, well, I don't want to be too much longer because we do have a fair number of people here. So let me get started and people can join as we go. My name is Erin Choquette. I'm the General Counsel for the Connecticut Paid Leave Authority. I'm joined this morning by Andrea Barton-Reeves, who's the CEO of the Connecticut Paid Leave Authority, and Amber Forrest, who is our Executive Assistant Extraordinaire, who's running the webinar for us. We will be recording this webinar, and we will also be able to provide you with a link to the slides if you would like after the seminar is over. As I'd indicated, if you have questions, please enter them into the Q&A function, and we will be able to respond to those during the course of the morning. I'm just going to pull up the slide show and start from the beginning. All right, so applying paid leave to your workplace, the practical and legal perspectives. We also have webinars on the basics of the paid leave, and we have webinars specifically geared to how to register your business and how to apply for a private plan if you're interested in that option. But today we're going to talk a little bit more directly about the interaction of the leave laws with the Connecticut Paid Leave Act. As I said, my name is Erin Choquette. I'm the General Counsel for the Connecticut Paid Leave Authority. Before joining the authority, I worked at the Department of Administrative Services in the state of Connecticut for about 14 years, over the course of 7 different commissioners. And I've been doing legal work and employment law related work for over 20 years, including a great deal of work in connection with the FMLA. This morning, we're going to do a quick overview of the Connecticut Paid Leave Program as a whole, with a focus on some key dates that people should be aware of. And then we're going to talk about the various leave laws and how they interact with claims administration, and in particular, what the role of the employer will be. If we have time, I'll show a couple of examples, and then I'll show you some resources we have on our website. And as I said, we will make time to address the questions you may bring to us. Andrea Barton-Reeves, our CEO, may respond to you directly during the course of the morning, or will address your questions live at the end of the formal part of the presentation. So the Connecticut Paid Leave Authority is a quasi-public agency that was created by statute, Public Act 19-25. And our purpose is to serve the growing need of providing financial relief to Connecticut families when they need to take time away from work due to their own serious health condition or to care for others, and to allow them to use those leave entitlements without worrying about the economic harm created by lost income. So our mission is twofold. First, it's to provide employees with pathways to accessing those leave benefits. And secondly, to empower employers, administrators, and healthcare providers in their roles in this process by giving them tools to understand their roles and providing them support as they navigate through the laws. The Connecticut Paid Leave Authority has many responsibilities set forth in the statute, which includes outreach and engagement, developing the policies and procedures needed to run the program, establishing the contribution rate, which is currently 1/2 of 1% of your subject weight earnings, and receiving those contributions. We also are required to create a path for a private plan option and to audit those private plans. And starting in January of 2022, we will be administering claims for paid leave benefits. That's really where we're going to spend most of our time this morning. Just to make sure everyone is familiar with the universe that we're talking about, I think it's helpful to just define our covered employers. So if you're a covered employer, your employees are responsible for making the contributions, and you are responsible for remitting those contributions. Your employees will be able to apply to the Paid Leave Authority for income replacement benefits starting in 2022. And the legislature deliberately defined covered employers very broadly to include essentially all employers who have one or more people working in Connecticut. Now, this includes nonprofits. It also includes private sector employers with a unionized workforce. The law also allows sole proprietors and self-employed individuals to choose to opt in. They're not required to participate, but if they choose to opt in, they must stay in the plan for at least 3 years. Now, if you're paying attention, you'll note that I said essentially all, but there are a few exceptions. And these exceptions are parallel to the employers who are not protected by the Connecticut FMLA under the existing statute. And that includes the federal government, the state of Connecticut, except as to our covered public employees, and municipal and local and regional boards of education, unless they have covered public employees. The law also excludes non-public elementary and secondary schools. Okay, so I keep saying except for covered public employees. Who are they? Well, all non-unionized employees of the state of Connecticut are covered under the program, which means all of us non-union employees will contribute to the program. Unionized employees of the state can collectively bargain to be included into the program as well. Employees of municipalities and employees of local and regional boards of education, both union and non-union, are excluded right now. But if the unionized employees of the municipality or the Board of Ed bargain to be included, then everybody comes in, both union and non-union. We've received a lot of questions to the authority about what's a municipality. And so I put the definition from the statute into this slide, just so you can see that a municipality means more than just a town or a city. It also includes some of the authorities or districts within a municipality. As I've said, sole proprietors and self-employed individuals may participate, but participation is voluntary. They have to affirmatively choose to enroll in the plan. If they do so, they have to stay in the plan and make their contributions for a minimum of 3 years. Their contribution rate will be the same as that of employees, which is 0.5% of their subject earnings. But since they're not receiving wages, their subject earnings are based on their self-employment taxes. So as I said, the authority is responsible for managing the contributions. So this slide is just intended to give a quick bird's eye view of what that means. So employees make contributions of 0.5% of their wages, or self-employed and sole proprietors do. The employer will remit those contributions and the wage information. It's very minimal wage information. It's just to help us ensure that we're getting the right amount in the contributions. The authority receives those contributions and validates the information provided. And the contributions are deposited into a paid leave trust, which is managed by the Office of the State Treasurer. It's important to know that the paid leave trust is not considered state property. It can only be used for purposes of funding the benefits and administering the paid leave authority. It cannot be used for any other purposes. It cannot be swept and used for any general fund ideas. As I'd mentioned before, there is a private plan option. Under this option, employers can seek approval from the Connecticut Paid Leave Authority to offer their own employees a private plan, something that they offer just for their own employees, instead of having their employees contribute to and receive benefits from the Connecticut Paid Leave Authority. If an employer wants to offer a private plan, it must offer the same or better benefits as the public plan. It must comply with all of the statutory requirements. And that means most short-term and long-term disability policies will not be sufficient, because most of them do not provide the same extent of coverage for all the same reasons, all the same benefit amounts, and for the same length of time. Employers can take a deduction from their employees' wages to fund the private plan, but it cannot be greater than the cost of the contribution that they would have otherwise paid into the public plan. So right now it's limited to 0.5 of 1%. Employers must demonstrate that they can run this plan, and they must hold a vote. So the Connecticut Paid Leave Program is an entirely employee-funded program. And as such, the legislature felt it was very important that the employees make a decision about whether they want to be in the public plan through the Connecticut Paid Leave Authority, or if they're okay with the private plan their employer would like to offer. And so if the employer wants to apply for a private plan, they must hold a vote of all of their employees working in Connecticut, and a majority of the employees working in Connecticut must vote in favor of it. Then they can submit their application to the authority. If the authority approves the plan, the employer is responsible for providing this benefit to the employees. This slide identifies some key dates and some really helpful information to you. And I think the most important information is that the ConnecticutPaidLeave.org, which is the Connecticut Paid Leave Authority's website, was launched in early September. And in fact, it's been expanded upon several times since then. This website has all sorts of useful information, specifically geared toward employers, employees, third-party administrators, healthcare providers. It's got videos, it's got FAQs. It's also where you'll go to register if you're an employer. It's where you can go to make your contributions or remit your employees' contributions. It's really the workhorse. Now, on November 23rd, employer registration officially begins. We actually started registration at the beginning of November as a soft launch. So if you wanted to, you could go in now and make your registration. But November 23rd is the official launch. That's what we're really publishing it. Starting in January of 2021, the requirement to start making the deductions begins. So after that first paycheck on January 1st, 2021, employers will start deducting the contributions from the employee's wages. As I said, if a sole proprietor or self-employed individual has enrolled in the program, they can also start making contributions. And then in January of 2022, you can start submitting your applications to receive income replacement benefits. So as a lawyer, I do like to start with the leave laws. I think it's helpful to create the context. And I think it's also important to understand that the Connecticut Paid Leave Act is part of a larger constellation of laws. There are several laws which provide job-protected leave, and then there's a couple laws which provide income replacement during leave. Job protection can be found through the federal FMLA, if you are an employer with 50 or more employees, or the Connecticut FMLA. Right now, and up until January 1st, 2022, Connecticut FMLA applies only to employers with 75 or more employees. But in January of 2022, it will start applying to employers with 1 or more employees. Workers' compensation provides a limited amount of job protection for people who have covered on the job injuries or illnesses. And then the Americans with Disabilities Act, the Pregnancy Disabilities Act, and the Connecticut Fair Employment Practices Act provide protection for individuals who have disabilities or who are pregnant. And under all of these laws, leave may be a reasonable accommodation. So that's really the laws that you expect to see when you're talking about job protection. There are also laws that offer income replacement during leave. And the Connecticut Paid Leave Act, which applies to employers with 1 or more employees working in Connecticut, as we discussed, will start providing income replacement in January of 2022. And then, of course, workers' compensation, as always, remains unchanged and will provide income replacement for covered on the job injuries or illnesses. It's important to note that if an employee is receiving workers' comp benefits, they cannot simultaneously receive benefits from the Connecticut Paid Leave Authority. So there are various reasons that someone could take leave, job-protected leave, under federal or state FMLA. And these are the same reasons that an employee could receive income replacement benefits under the Connecticut Paid Leave Act. If you're creating or expanding your family after the birth of a child or the placement of a child with your family for adoption or foster care, we call that bonding leave. You can take time away to be with the baby or the new child. You can also take caregiver leave to care for a family member who has a serious health condition. Of course, you can take leave to care for yourself if you have your own serious health condition. And I want to point out that a serious health condition includes serving as an organ or bone marrow donor. It also includes pregnancy. There's two types of military family leave. One of them is called military caregiver leave, and that's leave to care for a family member who was injured in the line of duty on active duty. There's also something called qualifying exigency leave, when a family member is called to overseas active duty, and your employee or you need to take time away from work to deal with some of the exigent circumstances around that, such as perhaps going to a sending off ceremony or having to make new arrangements for your finances and your legal new will and powers of attorney and such. Connecticut law also provides job-protected leave and the opportunity for income replacement in certain circumstances related to family violence. If you need time away from work to receive treatment or counseling, or to go to court, or to relocate for family violence situations, that is permitted under the family violence leave law. Apart from the family violence leave law, which is Connecticut law only, the real difference between federal FMLA and state FMLA and the Connecticut Paid Leave Act is the definition of family member. Under federal FMLA, a family is really your parent, your spouse, or a child who's under 18 or is over 18 and has a disability which prevents them from engaging in 3 or more activities of daily living. Under Connecticut FMLA and the Connecticut Paid Leave Act, a family is actually much broader and includes your parent or your spouse, your son or daughter of any age, as well as your sibling, your grandparent, your grandchild, or an individual related to the employee by blood or affinity whose close association the employee shows to be equivalent to those specific family members' relationships I listed above. So it is a broader group of people. I can tell you from doing FMLA for 20 years, we get lots of requests to take leave for an adult child or for a sibling or for a grandparent. And so the legislature has broadened the law to allow for that. So the length of leave or the length of time that you could receive paid leave benefits differs depending upon which law you're talking about. Federal FMLA says it's 12 weeks in a 12-month period, except that you could actually take 26 weeks of leave in the 12-month period for military caregiver leave. Under existing Connecticut FMLA, the law is actually 16 weeks in a 24-month period. But as of January 1st, 2022, the leave will change and make it look a little bit closer to federal FMLA because it will be 12 weeks of leave in the 12-month period, except that you also get that 26 weeks of job protection leave for military caregiver. Up to 12 days out of the 12 weeks could be used for family violence. And there's also a provision that an individual who's incapacitated due to pregnancy could qualify for an extra 2 weeks of job protection leave. Under the Connecticut Paid Leave Act, you get up to 12 weeks of income replacement benefits in a 12-week period for all of the leave reasons, including military caregiver, except that you can only get 12 days of income replacement out of the 12 weeks for family violence. And you might also be able to get the 2 additional weeks of income replacement during leave for incapacity. So it's generally 12 weeks with a couple of exceptions. Just like the leave laws have slightly different benefit amounts, the eligibility requirements are also slightly different. For federal FMLA, in order to be eligible for the job protected leave, you have to be employed by the employer for at least 12 months, and you have to have worked for at least 1,250 hours in the 12 months immediately preceding the leave. Under existing Connecticut FMLA, it's similar. It's actually 1,000 hours, but it's still the 12 months. But as of January 1st, 2022, it's going to change pretty drastically. And now you will only have to work for the employer for 3 months in order to qualify for job protected leave. And there is no hours worked requirement. Now for the Connecticut Paid Leave Act, our eligibility requirement is different again. and it really focuses on how much the individual has earned. If you have earned at least $2,325 in the highest earning quarter of the first 4 of the 5 most recent quarters, and you are currently employed in Connecticut, or you had been working in Connecticut during the past 12 weeks, you're eligible for leave. Now, you could earn that $2,325 from more than one employer. The Paid Leave Authority is working with the Department of Labor to be able to validate that, because individual employers may not know that you're working for multiple employers, but we'll be able to make that determination. Again, a sole proprietor or self-employed individual who has earned the same amount could also receive benefits if they've enrolled. As you can see, job-protected leave and income replacement have different eligibility requirements, which means a person may be eligible for one, but not both. So let's get into that a little bit more through the claims administration process. When we're talking about the paid leave benefits, the employee will apply to the Connecticut Paid Leave Authority for those income replacement benefits. They do not apply to us for job-protected leave. They're just looking to us for the income. We will validate that they're eligible, and we'll also validate that the reason they're seeking benefits qualifies. We'll calculate the benefit amount, and then we have to communicate with the employee and the employer to validate when the employee is actually out of work, and to calculate any offsets that may be based on employer-provided paid time off. Once we've done that, we'll issue the benefit payments. Now, I have to take a break because the definition of what those paid leave benefits will look like is somewhat complicated. So give me a second. Okay. If you earn less than or equal to the Connecticut minimum wage multiplied by 40, your weekly benefit will be 95% of your base weekly earnings. If you earn more than the Connecticut minimum wage times 40, you'll receive 95% of your weekly wage multiplied by 40. Sorry, up to that Connecticut minimum wage multiplied by 40, plus 60% of the amount that your base weekly earnings exceeds the Connecticut minimum wage multiplied by 40. However, in all circumstances, the total weekly benefit payment is capped at 60 times Connecticut minimum wage. So I don't know about you all, but I like to see that carried out with the math. So that's what this slide does. I'm not going to go through all of the scenarios, but I just wanted to lay out for you sort of the assumptions that are behind this. First, I've excluded all the tax issues. Like, I'm just making it simple in terms of figuring out the $500 a week. We're just going to go with 500. We're not going to figure out what the deductions are first. I'm also putting us forward in time to the date when our Connecticut minimum wage will be $15 an hour. That's coming soon. And frankly, it makes the math easier. So I've used that number. 40 times 15 is 600. 60 times 15 is 900, right? So if you have an employee who's earning less than the Connecticut minimum wage times 40, their weekly benefit will be 95% of that amount. So in scenario 1, since Lee earns $500 a week, his weekly benefit will be 95% of that, or $475. A person who's earning more than 40 times the minimum wage has the more complicated math. So let's look at scenario 3. Alex is earning $1,000 a week, so his or her weekly benefit will be 95% of 40 times the minimum wage, plus 60% of the difference between Alex's weekly wage and the 600, which in this case would be $400. So if you do the math, you see that that equals $810. Since $810 is less than 60 times the Connecticut minimum wage, Alex will receive $810 a week in income replacement benefits. Riley, on the other hand, is earning a little bit more money. Riley's earning $1,250 a week. So when you do the math, you see that 95 times 40 times 15 plus 60% times the difference exceeds $900. In fact, if you did the math, Riley's average weekly benefit would be $960, but that's over the cap. And so in this scenario, Riley would also receive $900 a week in income replacement benefits. Okay, so that's what the Connecticut Paid Leave Authority is going to be doing. But what will the employers be doing? Well, the employer gets into the mix when an employee requests time away from work for a potentially FMLA qualifying reason. And every time an employee does that, right now you should be doing this too, but you'll definitely be doing this in 2022 once the income replacement is available. You need to think, is the employee eligible for job-protected leave under one or more statutes? And is the employee eligible for any income replacement while on leave? Both of these questions must be addressed every time. So first we start with eligibility for job-protected leave. Do you have more than 50 employees? Has the employee worked for you for more than a year and more than 1,250 hours? Is the reason covered by federal FMLA? And has the employee already used the leave entitlement in the 12-month period? Then you ask, okay, are they eligible for state FMLA? And on this slide, I've listed the eligibility requirements effective January 1st, 2022. So the one or more employee working for you for at least 3 months, the reason for leave, and have they used up their entitlement? Now, are they eligible for other job-protected leave? As I indicated, with ADA and Pregnancy Disability Act, those apply to employers with 15 or more employees, and CFIPA applies to you if you have 3 or more employees. An employee could be eligible for just federal FMLA, just state leave, both federal and state FMLA, which would run concurrently. They might not be eligible for either, but they could get job-protected leave as a reasonable accommodation, or perhaps they're not eligible for any job-protected leave at all. So you need to figure out what their eligibility is, and then you need to tell them what the circumstances are. Just as a reminder, reasonable accommodation under ADA, CFIPA, and Pregnancy Disability Act is defined as a modification or adjustment that enables a qualified individual with a disability to be considered for a position, to enjoy equal benefits and privileges of employment, or to perform the essential functions of the job. To be a reasonable accommodation, it cannot create an undue hardship, which is defined by law, and it must be not only reasonable, but also necessary and effective. It's well established and has been the case for, the 30 years since ADA has been a law, that leave may be a reasonable accommodation. So that's why we want to make sure everyone is paying attention to that. So, as I said, an employee may be eligible for leave, job-protected leave. They may also be eligible for income replacement, and they may be eligible for income replacement even if they're not eligible for job protection. So those two questions don't always go together. The first question is this covered by workers' comp? If it's covered by workers' comp, you're going to go with your regular processes, and you know that they're not eligible for paid leave benefits under the authority. If they're not, there's two questions. Are they eligible for benefits from the paid leave authority? And is the employee eligible for any employer-provided income replacement benefits, like sick leave or vacation or other paid time off? For the employer, your job is to tell the employee if they're eligible for any employer-provided income replacement. And so you let them know, what are your rules about sick leave or vacation leave? The paid family leave laws do not require employers to make any changes to your existing policies about paid time off, with one exception. And that's a big one, so we flagged it. You cannot require them to spend down all of their vacation while they're out on FMLA. You have to let them keep at least 2 weeks of vacation or related paid time off. So bearing that in mind, you as the employer will let the employee know if they're going to be required to use some or all of their leave accruals. And you should also let them know that the employee, may want to apply to the paid leave authority for paid leave benefits. The employer is not going to make the decision about whether the employee is eligible for benefits from the paid leave authority. But I think it's important for you to know that employees might be eligible for benefits, even if they're not eligible for any benefits from the employer, and even if they're not eligible for job-protected leave. Now, we have this asterisk here where we say you don't make the decision about paid leave benefits unless you have an approved private plan. Part of having an approved private plan means that you are going to be making that determination of eligibility for benefits under the plan. But in doing so, you have to comply with the law, or you have your insurer or third-party administrator comply with the law. An employee could receive paid leave benefits from both the paid leave authority and the employer, provided that the income replacement does not exceed 100%. Now, we know a lot of employers offer short-term or long-term disability policies. And as I've mentioned, those generally will not be sufficient to qualify as a private plan, but you may still have them for your employees as another layer of protection. Generally speaking, most short-term or long-term disability policies state in the contract that state-provided paid leave benefits must be used first. So if you have those policies, it's important to review the terms of the policies and make sure you understand them. So let's see what time it is. It is 8:32. I'm just going to give one example, and then I'll show you some helpful hints, and then we can get to your questions. So in this example, Acme Industries has 100 employees working in Connecticut, and Wiley Coyote is a full-time employee who's worked for Acme for 10 years. He's got 4 weeks of sick leave and 2 weeks of vacation. And unfortunately, Wiley hurt himself and needs to be out of work for 8 weeks. So every time an employee tells you they need to be out of work for a potentially FMLA qualifying reason, and a significant non-work-related fireworks accident seems to qualify, you have to ask, is the employee eligible for job-protected leave? And is the employee eligible for income replacement benefits? So, given the size of Acme, we know that it's a covered employer for purposes of Connecticut FMLA and federal FMLA. And we know that Wiley's been working there for several years. So and as a full-time employee, we're going to assume he met the hours. So he's definitely eligible for both Connecticut FMLA and federal FMLA. We're going to also assume, based on his full-time status and tenure there, that he's probably earned enough to qualify for Connecticut leave benefits. So Wiley got hurt, and his first day he's out of work is February 1st. So Connecticut FMLA and federal FMLA will start on that first day he's out of work, and will continue, and they'll run concurrently through the entire 8 weeks. Now, Acme has a policy which says employees have to use their sick leave accruals anytime they're out for their own serious health condition. So Wiley's going to use his 4 weeks of sick leave accruals to begin with when he goes out from work. He's only got 2 weeks of vacation, and the employer can't require him to use that. So once he's out of sick leave, he can apply to the Connecticut Paid Leave Authority to receive income replacement for the 4 additional weeks that he's out of work. So Wiley's going to come back to work in 8 weeks, and he'll have 4 weeks of Connecticut FMLA and 4 weeks of federal FMLA remaining on the books in the 12-month period, in case he gets hurt or injured again or has to take leave to care for someone. And since he's only used 4 weeks of Connecticut paid leave benefits, he'll actually have 8 weeks of income replacement entitlement available to him in case he has another qualifying reason, again, in the next 12 months. All right, I'm going to skip through the next example for now, just to flag one thing for employers who have employees who are married and work for you. If you have spouses who work for the same employer, they have to share their job-protected leave under federal FMLA if the reason is to bond with a child or to care for a parent. Under state FMLA, starting in January of 2022, they'll have to share that 12 weeks if it's bonding or to care for a family member with a serious health condition. This means that if the first spouse takes 6 weeks to care for a family member with a serious health condition, the other spouse can only use 6 weeks to care for a family member with a serious health condition. If they need the leave for their own serious health condition, they each have 12 weeks. Under the Connecticut paid leave law, there is no requirement to share that benefit. They'll each get their 12 weeks of paid leave benefits from the authority, assuming they have a qualifying condition. Giving you a lot of information in the course of 35 minutes. So that's a lot to take into consideration. So I strongly recommend that you go to our website when you have some time to look around in it. It's connecticutpaidleave.org. And as I said, it's got all sorts of useful information, including an employee rights poster, a rack card, a paycheck mailer that you could send out, FAQs that you could email or send out, and there's a complete employer toolkit, which has all of this and more. These documents are all available to you in color and black and white if you want to mail them or email them or print them out. We strongly encourage you to share this information with your employees before January so that they know why the deductions are coming and so they won't be surprised. In addition to all of this information, there's also videos on our website that can help you understand the Leave Act and the processes. There's also frequently asked questions that you can access through the website. If those various resources still don't answer your questions, we have a contact us button on the portal, or you can email us directly at support@ctpaidleave.org. And we have a team of people who are responding to those emails. All right, I'm going to stop sharing my screen, and I'm going to ask Andrea to go off mute if she's here, and then we can go through some of the questions that have been asked during the course of the morning.
So I'm going to, there's a few, I've answered most of them, but some of them I've left for you because I think people would benefit from hearing the answer. So the first question was, the one that I left open was a further discussion about the equivalent definition with respect to family, because I know that's a question we get quite often about the expanded definition of family. So if you would address that one, and then there's a few more that we can go through as well.
Okay, so Andrea, it's a little hard to hear you, but what I think I heard you say is that there's a question about the affinity, sort of who's the equivalent to a family member?
Yes, that's right.
Right, so actually, the Connecticut Paid Leave Authority issued a policy, a draft policy that we put out for public comment, and actually the comment period closes tomorrow, and then the board will vote. So we have a draft definition of that, which is based on the definition that is used in the federal government for federal contractor sick leave requirements, as well as bereavement leave. And so since they've been using this definition for 20 years, we're going to try and copy it. And basically it means you have to show that you have a relationship that is equivalent to a family relationship, even if it's not a blood or marriage relationship. And some of the examples are, your great aunt who, for whom you buy groceries every week and who is celebrating every holiday with you, except probably this Thanksgiving, and who really stands in the place of your grandmother. Your grandmother died when you were little, and your great aunt has been the one who comes to Grandparents' Day. That would be an equivalent relationship. Or, for example, you are an only child, but you have a very, very close friend who's been a friend since childhood and stood up for you at your marriage and comes to family events and is really, the equivalent to your brother. You don't have one by birth, but this is truly your brother and not just a person you hang out with. That might be someone. It could be a person with whom you share a household and you share the house, you share the expenses, you share responsibility for any children in the house, but you're not married. So those are all situations where you may have a affinity, a relationship by affinity as opposed to blood or law. So I see that Amber said that we have a person with their hand up. Do we want to? I can see, is this Alexa Greenberg? I can, yes. Alexa, probably the easiest thing would be to type your question into the Q&A. So, all right, let's go back into the Q&A and say, okay, if an employer has a general PTO policy that covers sick time and vacation time, does the same requirement apply? Employee has to keep the 2 weeks of time. Yes, if your PTO policy does not distinguish between sick time and vacation time, then that requirement to allow 2 weeks still applies. There's also a similar question in the chat, which says, if you've got 4 weeks of PTO and they've used up 3, for leisure, which they're allowed to do, and then they get sick, can the employer require them to use the last week? And the answer is no. You do not have the right to say, well, you used 3 weeks for vacation and now you're sick, so we want you to use the last week for sick time. If your PTO is sort of a general bucket, then you have to allow them to keep 2. Another good question. Can you define a Connecticut employee? Is that someone paying state income tax? Anyone paying state income tax for whom an employee is also paying Connecticut UI? Yes, basically. We're using those two. If you're paying Connecticut unemployment for your employee and you're paying Connecticut state income tax for your employee, then they're working in Connecticut and they'll need to contribute. I think thank you for asking this question, because I want to point out that you could have employees who live in Connecticut but work in another state. They're not covered. Employees who live in another state but work in Connecticut are covered. It really focuses on where they're working. And as this person indicated, the best way of determining that is to look and see, are you saying they're working in Connecticut for unemployment? Then they're working in Connecticut for S2. Oh, Alexa did not mean to raise her hand, so that's fine. I'm glad we didn't call on you and make you have to speak to us.
Okay. Erin, let me take a look through the list. I know that there was one other. Here's a good one. Here's one about timing of the private plan. I did answer it, but the question is, if a company is approved late in 2021 to have a private plan, what happens to the employee deductions already submitted to the state? So the way that I answered is this, that we're really not encouraging you to collect those deductions and submit them to the state if you think you're going to offer a private plan. You really should hold on to those, and you should withhold and hold them in escrow and then hold your vote. And depending on the outcome of the vote, then you can remit those withholdings to the paid leave authority, or you can hold on to them as the employer. If you're, and then Erin, maybe you can speak to how withholdings for the private plan can be used by an employer, because there are some limitations to that. And then I'll find other questions for you.
Great. So as we mentioned, the statute allows for an employer with an approved private plan to take withholdings from their employees. It cannot be more than the withholdings that they would be contributing to the public plan. So right now that's 0.5%. And they can only use that money for the administration of the private plan itself. So you can't sort of put it into a pool and use it for sort of other benefits. It can only be used to provide the employees with the income replacement associated with FMLA.
Okay. Then a question asked early in the webinar was about the payroll deduction and which payroll and from which payroll the withholding should start. So the question is, you said first payroll after 1/1/2020. Is that after or on or after? So essentially it's a question about timing, right? Which is the right payroll. So I told them that we'd ask you to answer that question live because it's asked pretty frequently.
Right. So the first paycheck that you issue after January 1st, that should be the paycheck from which the 5% is, the 0.5% is taken. So if it's issued on January 3rd or January 12th, either one, you take the 0.5% out of that entire paycheck.
So but a follow-up to that question that we get fairly frequently, Erin, is what if that paycheck sort of bridges 2020 wages and 2021 wages? So how would an employer handle that?
So regardless of whether it bridges, the way that we understand the statute is And this is similar to how Social Security is done and how other similar requirements are done, is that it doesn't matter sort of the days that are included in the paycheck. It really just matters when that paycheck was issued. And so if you've got a paycheck issued on January 3rd, that encompasses time from in December, you still take the 0.5% out of that entire paycheck.
Okay, thank you. So the next question is about an employee with multiple employers. If a Connecticut employee works for 2 companies and will they contribute under both companies, or can they select one of the companies to contribute under?
They're actually going to contribute under both companies. And that way you're getting 0.5% taken out of each paycheck. And then, as I said, in terms of determining eligibility, we'll be able to look at your employee records for both jobs and pull that money together to show that you earned the 2325.
Right. So what I would also add, and this is probably not applicable to most people who have multiple jobs, but there is a wage cap over which contributions cannot be taken, and that's the Social Security contribution wage cap, which right now is about $137,000. So if you make more than that, then those wages above that would not be subject to contribution withholding. But what we found is that most people who are working multiple jobs, that's not the issue for them. But in case you needed to know that, then that's the wage cap. And here's a question. I'm sorry, go ahead, Ari, you were gonna.
No, I was just nodding to agree with you. I think you and I are both looking at that same question, basically a stacking question.
No, I'm actually looking at the
Okay.
question about, I'm going through the ones where I said, Aaron's gonna answer this, so let me ask them to make sure they're answered. So can an employer adjust their paid benefits to make an employee whole from benefits they may receive from the authority? For example, if an employee's wages, weekly earnings are $1,250 and they receive $900 a week in income replacement benefits, can the employer tell their employee they will receive $350 a week from the employer?
Yes.
Yes.
Yeah. Employers can always be more generous. That is fine. And that's that idea of getting benefits concurrently from the employer and the employee, as long as it doesn't exceed 100.
Okay.
So,
Sorry. If you wanted to address the question, because I'm still in the answered. We can go back to the open.
yeah, I'm just going back to the
Okay.
open. So, so this question is, sorry, this one's been answered. If an person has 4 weeks sick pay and took 2 weeks vacation, do they get 12 additional weeks? And so basically this question is, what if one employee's never took their sick time and now they're sick? Are they going to get a different amount of paid sick leave? And this really is something that we call stacking. And
Yeah.
the way, that's why in the slideshow, I showed you that you really want to make sure that when you have an employee who has a serious health condition or is otherwise using is out of work for a qualifying condition, so caring for someone else or bonding, you want to make sure that you're designating that as FMLA covered. That is the employer's right and responsibility. Even if the employee says, no, I'll just use my sick leave, don't call it FMLA, you, the employer, have the right and the responsibility to designate it as FMLA and tell the employee that you're doing so. That ensures that the employee gets the benefit of the job protection, but it also prevents the stacking that this person was asking about. Because in that situation, their FMLA time and their sick leave are all being drawn at the same amount of time. And so you don't have someone who says, oh, let me use my sick leave now, and then I'll save my 12 weeks later.
Mm-hmm.
So there's some unavoidable stacking because eligibility is different, right? You could be, there's a question about, could you be eligible for federal and not state? Well, yes, if you had used up all of your state entitlement, perhaps you may be able to but you still meet the eligibility for federal. So you've used your state entitlement for a reason that's not covered by federal law. So say it's to care for your sibling, and then you end up breaking your own leg. You might not have any state leave available to you, but you might have federal leave available to you. So, as I said, you want to answer those questions every time because every scenario is different.
Right. I'm going back and forth between the answered and the open. So there's
Yeah.
there's a couple of questions in the open. The first is, if you pay into two jobs, do you get full benefit from both employers? And then the second, and we get this one a lot, is the authority looking at paid leave and CT FMLA is different. Would there be a time when someone who's eligible for CT FMLA and not be eligible for paid leave? So,
Yes. So let's do the two jobs because that's quicker and easier. So yes, if you're getting two jobs, then you're paying in from both of those jobs, and your benefit from the paid leave authority will be the 95% of that total wages, assuming you're not working both jobs, right? So you broke your leg and you can't do either your Monday through Friday job or your Saturday, Sunday job. You're going to apply to us. We're going to see that you have both jobs, that your wages are from both jobs, and therefore your benefits will be based on both jobs. So the other question is, are we looking at paid leave and CT FMLA is different? And yes, they are different laws. They're related. But as I mentioned, the eligibility is different, and the length of time is somewhat different. So there could be situations where a person could be eligible for job protection under Connecticut Family Medical Leave, but not eligible for paid leave. If you've worked for an employer for 3 months, but you haven't earned the 23-25 in the highest earning quarter of the first four, in one of the first four of the past 5 most recent quarters, you could get job protection but not have any entitlement to benefits from the authority. Conversely, you could be someone who has been working, right? And you recently switched jobs. So you've only been with your new employer for a month, so you don't have any job protection, but you meet the eligibility for income replacement. And so you could get benefits from us, even though you may not have job protection, but you're sick, you can't go to work, or you have to fly to Arizona to take care of your mother. We recognize that those situations occur. At least there'll be some income replacement for you. I'm just going to quickly scroll over. It looks like we've covered the questions in the chat, I think.
yeah, I thought there was one more.
Okay.
So there might be actually a couple more. I think one of them snuck into the chat. I'm gonna have to go back. I think I saw something there. So Mary asked a very interesting question, whether CT family medical leave, paid family medical leave will make the decision with respect to affinity. The way that I answer it is that when employees apply to us for benefits, then we certainly will be making that decision regarding affinity. But as Erin just pointed out, that there is somewhat of a separation between paid leave and family leave. So if the person is applying for family leave and they're applying for that for an affinity relationship, you as the employer will be making that determination. We wouldn't have any role in that as the paid leave authority unless they come to us looking for paid leave benefits.
Right. So, okay, I'm gonna scroll down.
Okay, then there was one in the chat. Let me see if I can catch it.
Yeah.
We may have answered it, but it
I think
reads,
I answered the one in the chat. So assume
okay.
2 employees have an issue that qualify for both federal and state FMLA and paid leave. Both have 2 weeks of vacation that stays. One had previously used all 2 weeks sick, I'm assuming, and the other has not used 2 weeks sick. How does the paid leave benefit differ? So in that situation, if the employer is requiring the employees to use their sick time that's available, the person who doesn't have any sick time available to them through the employer would come to the authority 2 weeks earlier, versus the employee who has 2 weeks of sick time on the books through their employer. So in that situation, the bar saying used paid employer provided accruals would be blank, and the person who'd already used all of their employer provided accruals in a different situation would be coming to the paid leave 2 weeks earlier. So there's also a question about making an employee whole. Can the employer choose to pay the employee their full earnings and then get reimbursement from the authority for the amount the authority would have otherwise paid? And the answer is no. That is not something that is available under the law. We have a new question in the chat, which is, can the employee use all of their PTO? If they choose to, they're certainly allowed to, right? I think one thing that's helpful in this process is the employer and the employee see each other on a daily basis, right? And the employer is going to know when the employee is out of work. And so the employer is going to say, hey, Erin, we've noticed you're out of work. And that's going to start the leave process if they don't ask directly. The paid leave authority will only know that people want benefits if they come to us, right? So in a situation where the employee says, I've got a ton of PTO, I'm going to use it up, even though I don't have to, I want to, they're allowed to do that. That's perfectly permissible. And then they can come to the authority if they have a situation later on.
Okay.
Right, so we are at 8:58. So we want to make sure that we stay on time. It looks like I think we've answered basically everything that I can see. If there are questions that you have that are not answered, other than sort of understanding the various permutations of stacking, which I think I've answered, even though, as I said, each one shows up as a slightly different situation. But if you do have any other questions that we haven't answered, I'd like to again recommend that you check out ctpaidleave.org. And then, as Amber is putting into the chat, you can submit any questions that you may have that you can't find answers to at support@ctpaidleave.org. Again, if you are an employer, we strongly recommend that you check out the website, register on the website, and share the information in the toolkit with your employees so that they know what to expect once the payroll deductions start coming in. We'd like to thank you very much for your attention this morning and ask you to keep an eye out for other webinars. We have a webinar on how to register your business, a webinar on private plans, and then another webinar on the basics of FMLA and paid leave if you're interested in that as well.
Okay. Thank you, Erin. Thank you, everyone, for attending.
Okay. Thank you all. I'm going to terminate the webinar. Have a good day, everybody.
Okay, thanks.